This is the October 28th, 2015 hearing of the Utah Board of Oil, Gas, and Mining. This is the time and place for agenda item number 1, docket number 2015-023, cause number S/049/0050 in the matter of Elite Rock West Mine. We'll take appearances at this time.
John Robinson of the Utah Attorney General's Office for the Division of Oil, Gas, and Mining.
Michael Stout of the law firm of Reed, Warlemont, and Stout on behalf of Wasatch Mountain Excavating.
For the record, would you spell your last name?
S-T-O-U-T.
And we would also, Mr. Shattle, would you introduce yourself?
Yes. My name is Matt Shadle. I'm the owner of this property. I represent Robert Aurora Sky LLC. I'm the managing member.
Thank you. Okay. Mr. Robinson.
Mr. Chairman and members of the board, as you know, the division has twice filed to continue this matter, and we thank you for your patience. That extra time has given us the opportunity to engage in good faith negotiations with Wasatch Excavating, which is the operator of this mine site. We were able to reach a deal yesterday, and that deal is a motion pending with Ms. Carter, and you have a stipulated order in front of you with the results of that deal. And I'm pleased to announce that I think both parties think this is in the best interests of each of them. And we filed this joint motion. I'd like to tell you a little bit about what the deal entails, and probably at the end of just a few minutes move the board to accept this motion, grant the motion, and enter the stipulated order. I have courtesy copies, I believe, in front of you from Ms. Carter, and so you can review.
Mr. Shattle, do you have can I interrupt you? Do you have a copy of this stipulated order?
No, I do not.
Could we get a copy to Mr. Shattle?
Yes.
John, I'm sorry to interrupt you. Please proceed.
Not at all. Thank you, Mr. Chairman. The gist of this stipulated order is essentially, I think, what we've called a friendly forfeiture in the past. So it has a lot of the elements of a forfeiture, but doesn't require going forward with a full proceeding. And the one difference between a forfeiture and the deal that we've worked out in this case is that any marginal difference between the cost of reclamation and the $10,000 bond that's being friendly forfeited will remain with the division for use on other reclamation projects. Under the rules, without a stipulated order of this sort, then the division would remit any remaining balance, any marginal difference between the cost of reclamation and the dollar value of the bond back to the operator. So in this case, if there is any marginal difference, the division will be able to use that in future reclamation efforts. And both parties, I think, feel that this is a clean and equitable way to move forward on this case. There have been some issues ongoing for a number of years, and with access and some other related issues at the site, ownership has changed at the mine site, and all parties to the stipulated agreement feel this is the best way to go forward and cleanest, simplest, and will protect the safety, welfare, environment of the state of Utah. This time I'd invite Mr. Stout to add anything that I've left out and invite any questions from the board.
Let's go with you, Mr. Stout, and then you may answer the questions the board members have.
I do not believe I have much to add, except that this is a situation where my client understands that essentially he could be leaving some money on the table, but it's a good resolution. He has had difficulty getting to the site. He hasn't owned the site. Wasatch Excavating has not owned the site since, I believe, 2009. He had done some reclamation since that time, and there were some disputes with Mr. Shadle about whether he can access the property or not. So at this point, the money, I believe, is with Chase Bank again. You may have read that the money was no longer with Chase Bank. It's been given back to Chase Bank, and they're holding it. And so, in the end, we think it's a good resolution for everybody. Ultimately, it kind of makes it so that the reclamation of this project will start from a clean slate. We added a provision in the stipulated order that Wasatch Mountain Excavating can bid on the project, and I think ultimately, if it's a type of project that there's no other bidders, they feel that they have some obligation, I think they'll submit a fair bid. And I think by all accounts, it's going to be significantly less than the $10,000. A portion of the $10,000 also goes to pay some past due permitting fees, $750. But other than that, I don't have anything else to add.
John, I have a question. The original surety on this was $10,000 bond, was it not?
That's correct. It was held in a CD account at Chase Bank for the benefit of the division.
If we expect there to be extra money or money left on the table, why is condition 6 in this order?
For the record, condition 6 says Wasatch Mountain will not be liable for any reclamation costs that exceed the value of the payment.
Mr. Brown, that is, I think the standard lawyering term. The division and our reclamation specialists feel confident that the price will come in underneath that $10,000 ceiling, and felt that the risk of it going over was minimal. But of course, you can understand how the respondent in this case doesn't necessarily want to be on the hook if there's some sort of contracting snafu and things, go sideways when the reclamation actually starts.
So who is on the hook at that point? Is that then the division's or the state of Utah's liability?
Well, Mr. Brown, I think that would be in the entirely unlikely case that it did go over. There would be the state of Utah and the division would be on the hook, but again, the division feels supremely confident that that won't be the case in this scenario. The reclamation needs at the site are mostly the removal of some rocks and boulders, the removal of some concrete and rebar, and reseeding. And where this isn't a particularly difficult site to mobilize to, it's in Utah County. It's probably not going to be very expensive. Estimates run somewhere between $3,500 to $7,500. Thank you.
Board members, other questions? Mr. Shadle, do you have any comments?
Well-
Just to be clear, you own the land and Elite Rock is the lessee?
Negative. Little background first. Elite Rock somehow was tied in with a company here called Wasatch Excavating, as far as I know, because I think that's what we're talking about here. I wasn't around at the time when they trampled over the ground, left debris all over the place, and maybe y'all ought to come out and take a look for yourself. It's going to be a substantial amount of material to remove. I do not want it buried on my land. They hauled it in. I want it all hauled out. I think it's, to put this very straightforward for y'all, I think it's gross negligence that they would say that it would be about $3,500 or $6,000 to take care of this. I don't see how. I really don't. So, little history. They worked on the place. It's been sitting idle for a very, very long time. They did have a conversation with me a year or two ago. They called up out of the blue and said to me, we're going to remove the gravel piles on the property, and that will help pay us to clean up the property and remove all the other debris. And I said to them, no way. You're not going to have a key to come on my property and steal my gravel piles. I purchased the property from FDIC. FDIC, they took the property away from Barnes Bank. Remember when Barnes Bank went under? That's how this all came to be. And when Wasatch Excavating went under, Barnes Bank took it from them, FDIC took it from them, and I bought it from FDIC. Now, right now, we're operating the Spartacus mine. I have Johansson in there right now. They're doing a good job. We're going to be working with you on turning that over to me because we're going to keep that permit process in place. But this is a different animal. This is not, it's on my property, but it's not in the same spot. And I wish I would have brought pictures for you to see. This is the first board meeting I've ever been to. I'm glad I'm here so I could accurately tell you what's going on. And as a landowner, I run cows on my property. I want this cleaned up. I don't want it delayed. I know if there has to be a delay, I understand, I'm patient, but we've waited long enough. And I've got my whole place all fenced. It's all in Greenbelt except for the little 5 acres that we're mining on right now. And then I got this major eyesore going on where all this other debris has been dumped and big old boulders are all piled up. I'd like to see what their plan is, and I'd like to know how they arrived at that $3,500 because I think it's going to be far more than $10,000. I used to be in the contracting business years ago, and I would be very interested in bidding on this job myself to make sure this property gets cleaned up. But I don't think it's going to happen for less than 10. Thank you.
Okay, back to you, Mr. Robinson.
With the board's permission, Mr. Chairman, I'd invite Mr. Stout to address some of the testimony that you've heard from Mr. Shadle.
Oh.
Mr. Shadle's position's a little interesting to me. He had offered through his attorney to settle this matter if we were to give him the $10,000. The problem with that was we weren't able to reach a global resolution that included the division, Mr. Shadle, and Wasatch Excavating. Essentially, the dispute comes down to is what Mr. Shadle will allow to be done on his property. And ultimately, from what I hear today, it may require the board to order. I think you're going to see that the reclamation costs for what the division is going to require to be reclaimed. Thank you. Is that good?
You're not being recorded. We can hear
Okay.
you, but you're not being recorded on.
Good. Is that better?
Yeah.
What it's going to take to reclaim the property based on what the statutory scheme requires is significantly less than $10,000. I believe what Mr. Shadle thinks needs to be done out there, what he'd like to see his land cleaned up, is outside of what the state requires for it to be reclaimed. So that's really where the difference is. And ultimately, I think you may be able to glean today, Wasatch Mountain Excavating could not feel comfortable going out to reclaim this property. That's one of the reasons why this deal was brokered the way it was. Mr. Shadle has threatened to sue him for trespass that he's already, when he was trying to do the last reclamation. There's a lot of issues here, and what we believe is that, as I mentioned before, this creates a clean slate of what it, now it becomes where you'll get new bids for reclamation. I believe Wasatch Mountain Excavating is going to submit a bid because it feels it may be able to recapture some of the money that it believes it's leaving on the table here. But if we start from a clean slate, then whatever company goes out and reclaims it, that entity will be working with the state and not directly with Mr. Shadle. Under the current situation, the previous operator has to work with Mr. Shadle because now it's his property. Under this order being approved, then it kind of cuts out that controversy in it and the potential for controversy. It allows the state to go through its bidding process, obtain a reclamation contractor. That can be Mr. Shadle if he's qualified. It can be Wasatch Mountain Excavating. It could be somebody else. And then they can go out and work directly with the state. I think under that situation, the state has the power then to discuss with Mr. Shadle the reclamation process. It's interesting to me that Mr. Shadle comes before the board and says it's going to be significantly more when he had offered to just take the $10,000 and reclaim it himself.
Thank you, Mr. Shadle.
Yes, thank you. Well, as a matter of fact, I did offer to accept, to sign over their bond that I clean it up for $10,000. But keep in mind, I already have equipment on site, prepared, ready to do the work. And this is a question for you. Part of the reclamation process, isn't it fair to say that they must haul that debris off? I don't know. I don't know how this works, but what do they do with the debris? The debris didn't come from there. They hauled the debris in on the property, and I'm talking some nasty metal in the concrete, and there's a tremendous amount of debris on the property that was left from Wasatch Excavating. And I can only imagine, isn't it fair to say that if they hauled it in, shouldn't they be responsible to haul it off? You're not going to leave that on my property, are you?
Back to you, Mr. Robinson.
Mr. Shadle, I think that if you're speaking of concrete and rebar, I think the division is in agreement that those materials would be broken up, hauled away, taken to a landfill. With regard to other materials on site, the division's records don't show that anything was hauled in terms of rocks and gravel. That may or may not be so, but when you took title of the property from FDIC, this mine site was already active, and so it's not clear to me that your history is longer than the division's with this mine site with regard to knowing what took place on the site and what needs to be done to be remediated. We totally understand that as the property owner, you're a stakeholder, and that we will seek to work with you to make sure reclamation is carried out in a way that comports with your desires. But the statute and the rules under Utah law may or may not go to the degree that you seek, and we'll have to discuss that when reclamation takes place after the contract and bid process.
Thank you. Board members, we have a couple of options. I think it might be worthwhile to recess and discuss this for a few minutes, what our choices might be. It seems that a continuance of this until the next hearing, so that if there is some factual issues involved, we might be able to get a presentation on the facts, so that if we're going to make a final order or sign the stipulated order, we're making an informed decision. Board members, that's kind of where I'd recommend, but we want to go talk about it for a few minutes? Okay, we'll be in recess for a few minutes. Okay, we're back on the record. Ready? We're back on the record. The board has discussed this, and I think what we're going to do is admonish the division to give us more information, much more information on the compliance with what the rules required, the history, and in particular, what the rules require to be done, what's on site, and then to address the factual differences that have come up in terms of the parties involved. We're really uncomfortable with item number 6 on the stipulation. It doesn't mean that we will deny it. It just means that we're very uncomfortable signing that with the information that's before us today. And I think we, as a board, want to send the message that on these kinds of matters, and we're sorry we're picking on you guys today, Mr. Stout, going forward, it is the policy of this board and the feeling of this board that we want a lot more information, that we're going to be much stronger in terms of holding the permittee to the full extent of the operations and the bonding and the requirements under the rules. And I'll let other board members comment on that. So, but the order of this board will be that this matter will be continued until the December hearing, at which time we request the additional information be provided.
Mr. Chairman, would the board care for written briefing before that hearing, or does the board's preference indicate just a more full-fledged hearing with testimony on the record?
I think we'd like to have more testimony on the record, and we'd like to have the individuals from the Minerals Division make a presentation to us on what exactly they have looked at over time, as well as a really clear understanding of what the requirements are, how the bond at 10,000 was determined, and where we are today. And so I think that's the feeling of the board as I understand it. If anyone has anything they'd like to say at this time.
Well, I think we just, again, I'm probably being redundant with what the chairman just said, but it's important for us to understand how the division concluded what reclamation would be required and the dollar amount that would be required to get this done, so that we clearly understand I mean, there's been testimony given today that makes us wonder. We just need to understand we have, I think we have 8 small pictures in the packet of what the site looks like. It isn't evident from those pictures that this is an enormous issue, but we'd like some clarity around that. Maybe more detailed photographs, what the division expects in the form of reclamation, and that should suffice. That's what we really want to hear.
And Mr. Shadle, as you have a vested interest in this property, you're invited to show us whatever pictures or information you deem that we need to see.
Yes, I'm here to help. Thank you, Chair.
Mr. Chairman, can I just add a couple of things?
Yes, please.
One of the issues here, and I don't know, this is the first time I've appeared before this board, one of the issues here that we're facing, and I don't know how common it is, but you end up with a new landowner and a entity operator who is struggling between meeting the statutory requirements of reclamation and threats of civil lawsuit for trespass. It is my opinion that this board has the power to order Mr. Shadle to allow the operator back on the site, but that's been an issue. I think, for example, Mr. Shadle indicated he wanted this done quickly, as fast as possible. But in a recent letter from his attorney within the last, I believe, 45 days, he indicated he had to have a minimum of 30 days' notice. Now, my operator has equipment currently at Camp Williams. One of the discussions we've had here in the last week is he can just go down there. He's got equipment. He'll move men down there to do it. But we're running up against Mr. Shadle's belief that he has the right to say when and where and how the reclamation takes place. So we'll address that as you've requested, but that is an issue. And I'm not sure that the statutory scheme is clear about whether this board's authority to order a landowner, being Mr. Shadle in this case, to allow the operator onto his property and excuse the operator of any civil liability. And I just believe that's an issue that you may want to ponder, and I'll try to address it in any briefing we do. The other concern, obviously, my client has here is the cost. I'm not here doing pro bono work for my client, and so there's a cost factor here of how much time can he spend fighting the legal arguments over whether $10,000 is sufficient versus just going down there and reclaiming the property, because he believes that his cost is somewhere around $3,000 to $4,000. But at this point, you weigh that against a civil lawsuit from Mr. Shadle for trespassing onto his property. And so those are issues that we've been dealing with. Mr. Robinson and I have been working on this together for probably 60 days. And this was the best solution we came up with, and it eliminates some of those issues in our mind. I only say that to have you further contemplate the issues set forth in this case.
Any additional comments?
I believe my only comment is that you've asked us to make a decision based on information we really don't have.
And I respect that. I understand that you need more information.
Paragraph 6 is asking the board to approve reclamation that we don't really have the ability to determine will it actually go over $10,000 without seeing what the division had in mind as far as requirements for reclamation. And we don't know what the original permit said about how the site will be reclaimed. Can we bury concrete on site? Does it need to be hauled off? What was in that original agreement that he purchased, the owner purchased from the FDIC? There's just some things that we're not comfortable with right now. It doesn't say that we can't be comfortable on in the December hearing. Essentially, I think we're just asking for the division to provide us with more information.
And I fully respect that. It sounds like it's necessary. To be honest with you, I have a question in my mind whether the concrete and rebar that may be at the site is even related to this mine, and whether it really, for all looking at the statutory scheme and the requirements of reclamation, is this something that the prior landowner or Wasatch Excavating or the previous operator to Wasatch brought on the site that has little or nothing to do with the mine site and the actual reclamation. So I certainly appreciate the board's position, and we'll continue to cooperate and look forward to coming back on the 9th.
The division will work diligently in the next 6 weeks or so to prepare that information and testimony and presentation for you.
Thank you very much.
Thank you.
Just also, if the division would note the strengthened policy that this board is going to look at on this and future matters.
Duly noted.
All right, thank you very much. So is everyone clear on that we're continuing in this matter until I believe, the December 9th hearing? Oh, I'm sorry, Mr. Shadle.
Yeah, I just want to make sure I'm understanding this. So we're going to have a meeting in December. Anytime between now and then, if the gentleman representing Elite or Wasatch Excavating, whoever these guys are that went bankrupt before, if they ever need to get on the property, they can contact me. And it's totally incorrect that I never stopped them from getting on the property. I just didn't want them to steal the good gravel piles off the property. And that's what this is all about. He keeps reiterating this, And I hate to sound like a broken record, but I feel like I need to, speak up about this because it's not true. I want this property cleaned up, and I'm not here to hinder in any way the cleanup of this property. But I do have one last final question to ask. Find out how many loads of material there is to haul away that was left by Wasatch Excavating on this property, and then look at how much per cost just to dump it at the dump site, the waste. If you look at just that cost alone without any other cost, you'll see where I'm coming from. Thank you.
Okay, we're going to close this hearing. Thank you
Thank you.
for your assistance on this.
Thank you.
And we will now go to agenda item number 2, docket number 2015. Let me start over. Docket number 2015-024, cause number 139-135, in the matter of Badlands Energy. We'll take appearances at this time.
Thank you, Mr. Chairman. Relma Miller, McDonald and Miller, Mineral Legal Services for petitioner Badlands Energy Utah LLC.
Melissa Reynolds with the Utah Attorney General's Office for the Utah Division of Oil, Gas, and Mining.
Any others? Saying none to you. Ms. Miller.
Thank you, Mr. Chairman. It's going to take a minute to get my laptop fired up here. With me today from Badlands are John Oburn, land manager, Rick Kopp, geoscientist, and Deborah Ryan, consulting reservoir engineer. I would ask that they be sworn in at this time.
Raise your right hands, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. The resumes of all our witnesses were submitted as part of Exhibit A in this cause. I would note that Mr. Kopp has previously been recognized by this board as an expert in geology, specifically in docket number 2014-020, cause number 25904 in June of 2014. We request that he be recognized as an expert in geology for purposes of this hearing as well.
Thank you. Vision?
No objection.
Board members? Then he shall be admitted as an expert for the purposes of this hearing in geology.
Yes, thank you. Also, I would like to make sure that you all received the supplement to Exhibit Z filed by my office on Monday,
Yes.
and also revised Exhibits G through J filed late yesterday. I think we have copies.
And board members, I believe you have those in hard copy on your desk.
Yes.
And Division, do you have those?
I do.
Thank you. Yes.
I think that's all the housekeeping matters at this time. I will be moving for admission of all the exhibits at the end of our presentation in chief.
That's our preference.
Thank you. So Badlands is before the board today seeking an extension of the order entered in cause number 139-84, allowing up to 4 wells on each of the established Lower Green River Wasatch Formation sectional drilling units within the subject lands, as more particularly described in pages 2 and 3 of the amended request for agency action. If approved, the subject lands will then have the same well density authorized for the same pool as the rest of the greater Altamont Bluebell field. As testimony and exhibits submitted today will reflect, the data collected to date for the subject lands supports the commonality of the Lower Green River Wasatch Formation characteristics throughout the greater Altamont Bluebell Field, and therefore the board's findings and conclusions set forth in the 13984 order are equally applicable to the subject lands. Drilling units for the subject lands identified in the request were established by the board in its order entered on January 16, 1974, in cause number 13124. A second well for each drilling unit was authorized by the board in its order entered on April 17, 1985, in cause number 13942. And copies of all three orders, the 13124, the 13942, and the 13984 orders were collectively submitted as Exhibit Q. In addition, and in the interest of brevity, we request that the board take judicial notice of the exhibits and testimonies admitted into evidence in the 13984 hearing, rather than reiterating each point individually.
Division,
The division doesn't object.
board members? Judicial notice will be taken on those matters.
Thank you, Mr. Chairman. The board has jurisdiction over this matter pursuant to Utah Code Annotated Sections 40-653B and 40-6-6. So a bit of background information at this point, and Mr. Oborn will address it further in his testimony. The original intent of Badlands was to include all the remaining sections in Township 2 South, Range 1 East that were not covered by the 13984 or the 139-106 orders. That was 24 sections. But there were title issues encountered in when his broker went out into the county, so that request was, we decided to proceed with the initial request with only 14 sections. Those are sections 1, 9, 10, 12, 13, 15 to 17, and 19 through 24. Notice was sent to the all mineral, leasehold, and production interest owners and the governmental agencies involved in those lands. But after the initial filing, there were completion delays in completing a well, and Badlands requested leave to continue this matter until today. So additional production data could be reviewed. But during the delay, the title issues were resolved, and Badlands decided to move forward with all the sections in this township. So the amended request adds sections 26 to 35 of that township. And again, we sent a second mailing to all the owners and the governmental agencies affected. The mailings were sent to all the parties at their addresses of record as disclosed by the relevant UNA County and agency realty records. And again, Mr. Oborn will discuss that in more detail. And the record will also reflect that notice of the amended request was published on October 4th, 2015 in the Salt Lake Tribune and the Deseret Morning News, and on October 6th, 2015 in the UNA Basin Standard and Vernal Express. There's no staff memorandum filed by the division in this matter, but the record does include a letter from the Vernal Field Office of the BLM expressing the BLM's support for Badlands' request, with confirmation from the Ute Tribe Energy and Minerals Department that they support the request as well. And finally, the record includes letters from Rig 2 LLC and Crescent Point Energy supporting this request. We're aware of no objections or any other responses filed in this matter.
All right, then we would like to proceed, but at some point, may we ask you to explain, or you're one of your witnesses, the advantages of keeping the 640 spacing versus down spacing to 160s? At some point.
Yes, we will address that. I will begin my examination of Mr. Oborn. Would you state your name and business address for the record, please?
My name is John Oborn. That's O-B-O-U-R-N. My office address is 2713 West Long Drive, Littleton, Colorado, 80120, Unit A. I am presently assisting Badlands Energy in their Denver office as land manager and overseeing their land personnel and providing additional assistance at my office. I run a land service company and so brokerage company, and there are additional services that Badlands requires at this time for their leasing, drilling, hearing matters. So
So you are essentially acting as land manager for Badlands at this point?
yes.
Thank you. Could you tell us the relationship between Badlands and Gasco Energy?
Badlands acquired Gasco Energy earlier this year. The name change was effective April 21st. Those documents are on file in Duchesne and Uinta County at the time.
So there may be some records, well logs, reports, et cetera, filed in the name of Gasco, but Badlands now operates all those interests. Is that correct?
Yes, that's correct.
I show you Exhibit B on the screen. Could you tell us, was this prepared by you or by Badlands or your office personnel under your supervision and with your input?
Yes, this was prepared at Badlands offices by myself and a couple of the individuals in the land department who had organized all of the mineral ownership and leasehold ownership.
And this is a business record of Badlands, is that correct?
Yes.
Would you tell us about this exhibit, please?
The red outline is the current spacing for 2 wells per section. The yellow shown on the map are, that's where Badlands presently holds working interest through leases it has acquired. Varying, the yellow, it can be anywhere from 1% to 100% of working interest. It does vary. The yellow on the map does not represent 100% full working interest where you see it. It varies. But that is Badlands' working interest in these sections. The white is other parties. So other working interest owners, open mineral interest owners, those are lumped in the white. The brownish red is tribal, and blue in the upper portion in section 1 is open federal minerals.
And among those third-party working interest owners are Crescent Point, who approved.
Crescent Point, Bill Barrett Corporation, EP are some of the larger, Newfield, they're some of the larger working interest owners that are currently represented in this area.
I now show you the certificate of mailing filed initially with the original request and the certificate of service for the amended matter. Do you recognize the names on this list? I'll let you look through.
Yes, these are names that were compiled from records that we had internally at Badlands from title opinions, title reports, providing us with mineral owners, leasehold owners, overriding royalty interest owners, and they were compiled into a spreadsheet and then provided to Ms. Miller and then wound its way up into the mailings to the parties that needed to be handled for this hearing.
And just to clarify, the initial request, the mailing in the initial request was all the parties in the original 14 sections, is that correct?
Correct.
And then the second mailing, we identified, or we mailed to all the parties in the additional lands plus, in all the lands affected, is that right?
Correct.
Okay. And the division has brought to my attention that there were a couple of names on the list where we cannot confirm that they actually received the second mailing. Susan Bingham Boren, B-O-R-E-N, and Shauna Lee Brower. And there's some discrepancy as to the correct address. So would you like to comment on those?
We had, in looking at this map, you'll notice that the tribal comprises close to 50% of the area that would require notification. We had over 1,000 individuals that had to be notified for the remaining 50%. So 24 sections, 50% tribal, 50% over 1,000 people. We sent notifications to the last known addresses of record for the record title holders that were shown in title opinions, of which we had 10 title opinions out of the 24 sections showing us who the record title holders were. We had mineral ownership reports on the balance that were prepared by experienced landmen. So we did wind up with a very large database of mineral owners, open and leased, record title holders, in some cases deceased, and to that we went ahead and identified parties who were executing oil and gas leases, executing various documents that were not record title holders, but could be the heirs of an individual who had passed. And those individuals were also added to our mailing list in an effort to make sure that we got everybody covered and notified. When we're dealing with heirs, successor trustees, sometimes we do have varying addresses. And we're sending to the last address we have of record. We receive phone calls. They give us a new address or a second home address. We send out another package. Out of over 1,000 people, we now have two that, one that we know of the two did receive the package at a second address. The second, we will make sure that that one individual gets their package at, we'll need to find the address.
Right. Thank you. That concludes my examination of Mr. Ober.
Division?
With the board's permission, we'd ask that the division be permitted to ask the witness some questions.
Proceed.
Yeah, Dustin Doucette for the division. On Exhibit B, these tribal mineral interests, maybe I missed it, but are these leased out to anybody?
Not at this time.
Okay, and as far as, do you have any CAs established in this area that you're asking to be spaced today, or
No,
to change the spacing?
no CAs. There's very little federal minerals in this area. As you can see, Section 1, there's 80 acres of open federal, but no, there's very little federal in here. It's mostly tribal. There is some Alati, and the rest is fee. A little bit of state.
You have other agreements in place for the drilling units that are producing?
What form of agreement are you thinking?
Unit joint operating agreement, or,
JOA?
yeah.
On a section by section basis, we do have JOAs in place with our other working interest owners for the wells in 24, 17, and 19.
And that's for the entire section? That would cover the entire
Yes,
section?
those JOAs cover the entire section.
Okay. No further questions. Thanks.
Board members, any questions? I have a question then. Are you the operator, or is Badlands the operator of all of the sections that have yellow on Exhibit B?
At this time, there are 4 wells. As I mentioned, there's 2 wells in Section 24, 1 well in Section 17, 1 well in Section 19. Badlands is the operator of those wells. They are not yet the operator of additional wells as wells are proposed in the sections that show yellow. If it is a place that Badlands desires to drill a well down the road, they could be, in most instances, they would be the operator if they have the majority of the working interest. There are other parties with working interest in these sections right now that we are in discussions with, and they are proposing wells for next year, year after, that we are aware of. And so for their wells, they would be they would be the operator. Specifically, Crescent Point has notified us of their interest in drilling some wells in the southern portion of that outline next year. They will operate their wells within this spaced boundary.
Thank you. Call your next witness.
I would call Mr. Kopp. Please state your name and business address for the record.
Rick Kopp. Business address is 7979 East Tufts Avenue, Suite 1150, Denver, Colorado 80237.
And what is your current position with Badlands?
My current position is Chief Geoscientist with Badlands.
I show you Exhibit C through revised Exhibit J. Are those familiar to you? Are you familiar with those exhibits?
Yes, I am.
And were they prepared by you or by Badlands personnel under your supervision?
Yes, they were.
Explain Exhibit C to us, please.
Exhibit C is the greater Altamont Bluebell area incorporating into Uinta County on the east, Duchesne County on the west. The state of Utah map down in the lower left-hand corner with the yellow mark is the area shown in the larger map to the top. What the map shows is previous spacing orders that have been done within the region out here, with the orange or brownish color up there, 139-84-4, which was the original spacing of 4 wells per section, down spacing from the 1 to 2 wells per sections within the greater Altamont Bluebell field. The purple area to the south was spaced to 4 wells per section. Over to the, this doesn't, point out.
The laser.
Laser. Okay, this is not going to show up. The blue box to the northeast, 139-106-4, was recently spaced to 4 wells per sections within the Wasatch. The green area below it, 139-06, was spaced at 80 acres per well for Green River. The red outline in the midst of all of that is our proposed area for requesting downspacing to 4 wells per section. The yellow within there is the acreage under lease or working interest by Badlands, and also showing then the tribal acreage and the brown color inside.
And in response to the chairman's question earlier, why is Badlands requesting increased density rather than downspacing?
We are asking for increased density to economically and properly produce the oil and gas reserves that lie within the Wasatch section in the area. The increased density to 4 wells is being done not for a 160 to space in the center of a 160 thing. It's to better develop geologically all these discontinuous sands in this vicinity.
Moving on to Exhibit D. Tell us about this one, please.
Exhibit D is the same map you saw previously, showing the previous spacing order areas in here, but it does show the well density that was in the greater Altamont Bluebell field. The green is the producing oil wells. There are a few scattered black wells on here that have been abandoned due to economics over time. The red circled wells you see scattered all over are new locations, drilling wells, or wells currently being completed within the Green River and the Wasatch within this greater Altamont Bluebell area.
And Exhibit E?
Exhibit E is the detail then showing the previous map from Mr. Oborn, which then shows the outline of our proposed 4 wells per section area. Again, the yellow on the map is the Badlands working interest or lease areas. The brownish or reddish color in here is all of the tribal acreage within the vicinity and surrounding. The white areas shown on here is other mineral interest owners or lease interest owners in here of other companies present in here. The green is currently producing oil wells. The scattered black, as I mentioned before, are abandoned wells or non-producing wells currently within the vicinity out here. And the red circles then also indicate wells that are current locations, either permitted, being drilled, or being completed at the present time.
And Exhibit F, tell us about that, please.
Exhibit F is, again, the previous map showing all of the mineral interest owners and wells on here. It also shows the cross-sections that will be used to demonstrate the wells across here. The cross-sections incorporate all of the wells, whether in a west to east orientation or a north to south orientation, that have been drilled to date within the proposed area.
Moving on to revised Exhibit G. Tell us about this one, please.
Revised Exhibit G is a west to east structural cross-section incorporating all of the wells within the area. The second well from the left on there is a recent well that was drilled by Badlands in the area here. And then,
I think, just a moment, I'm sorry to interrupt you. This was revised to reflect.
reflect
What
that.
are the changes from the
okay.
initial
All right.
exhibit?
The risk of changes was that the well on the far left side over there, at the time the initial exhibit was presented, we only had logs. We only penetrated into the Green River section. It was revised after the well was finished drilling and TD'd and has been perforated within the Wasatch section alone, so we added that log section on there.
And
for
that is the case also with the following exhibits that have been revised, is it not?
Yes, it is.
Okay. I'm sorry, go ahead. Thank
Okay.
you.
All right. What this shows is an approximate west dip of the rocks in a west-east orientation in here of approximately 100 feet per mile structurally. The lower Green River, which is the primary producing horizons within the Green River, is shown with the blue line. The brown line on there then is the top of the Wasatch Formation. All of the lines in between are internal markers within both the lower Green River and the Wasatch. The Wasatch has been the primary producer in this area in the past and is currently being developed by Badlands in the area. The lower Green River is usually added as the production declines within there. This was just to show the structure relation in an east-west direction.
And just, all the wells are vertical wells at this point, right?
These are all vertical wells, yes. And just for clarification, what the well shows in the black on the left-hand column of each well symbol in there is the gamma ray, which was used for correlation of individual horizons, individual sands. The red horizon or column on the middle then is just the resistivity, which is also, again, to identify reservoirs in here. The black hash marks on the far right is the current perforations in the current producing wells or the old abandoned wells out here. And as you can see, most of those are in the Wasatch Formation that's out here. Just for clarification, the wells that have been producing over historical, there is on the bottom of those a narrative of their cumulative production, both oil, gas, and water.
And revised Exhibit H. Tell us about that, please.
Okay, revised Exhibit H again was to add the Wasatch to the Badlands well on the far left. And what this was done was to show the variability of all the different internal horizons, internal markers within the Wasatch in here. And as you can see, the variability and the thickness variabilities as the Wasatch discontinuous sands are being deposited in and marginal to the Lake Uinta, which sat here during Paleocene and Eocene time. In a west-east orientation, you can see that in the center of the area we're looking at, we see a tremendous thickening of the Flagstaff horizons with thinning and thickening of red beds and individual non-lacustrine horizons across the region.
Revised Exhibit I.
Revised Exhibit I, again, was to add the second well in here, to add the Wasatch section to it. This is a structural cross-section in a south to north dip orientation into the Paleo-Uinta Basin here. It shows once you come off the well to the very south, you might say a geologic shelf, dip is approximately 200 foot per mile to the north in a continuous direction.
And Exhibit J.
Exhibit J then is a stratigraphic map hung on the top of the lower Green River, again to show the variability and thickness changes that occur within the internal markers within the Wasatch. Again, the gamma ray on the right column of each well column is used for correlation purposes of all these discontinuous sands. And most of these sands do not correlate from well to well on the spacings of the wells currently drilled in the area. The red, again, is resistivity used to identify reservoirs. The black is the current perforations and completion intervals of the wells out here. At the present time, within the proposed unit out here, there are 4 producing wells. All other wells have been abandoned within the proposed area. One well, Badlands completion, originally a Gasco, was completed in the lower Green River only. The last 3 wells are currently either producing from or are being completed and tested in the Wasatch section.
So in preparation for this hearing, you reviewed the testimony and the exhibits entered into evidence in the 13984 hearing, is that correct?
Yes, I did.
And you, in your expert opinion, the geology appears analogous?
Geology is very analogous to the greater Altamont Bluebell field area and to the whole Uinta Basin. Correlation of individual markers demonstrated and in publications by numerous entities have shown that correlation to wells with the individual sand sometimes does not carry more than a quarter mile. One of the results that everybody has always talked about in the past is as a bottle per se, the greater Altamont Bluebell, the pressure's been declining. The last 3 wells that were drilled out there, original pressures or very close to it was encountered in the completion of the last 3 wells Badland drilled out here within this area. So we feel that this area definitely is an area where downspacing to properly produce and evaluate the resource that's present here is necessary to be done.
You said downspacing, but the spacing, maintain the 640
Maintain
acre
this,
spacing,
yes.
is that right?
That's right.
Okay.
Sorry.
Any other comments you'd care to make? That concludes my examination, Mr. Kopp.
Division?
Thank you, Mr. Chairman. Again, the division has a couple of questions for the witness, and then I would also like to ask a question.
Yeah, Dustin Doucette again for the division. Mr. Kopp, you just testified that the last 3 wells had near virgin pressure basically in their completion. How close were those wells to offset wells?
The last well drilled had a well approximately 160 acres away. It was drilled in 1974, and it had produced almost 50,000 barrels of oil before it was abandoned economically. The second well drilled out there, again, had another well, almost 160 acre offset to it, and it had produced over 50,000 barrels before it was abandoned due to economics in the 1990s. The other well that was drilled did not have another Wasatch well anywhere close to it. And pressures released in there gave a calculated range of 0.69 to 0.72 pressure gradient which was the original, and it was also published by some current things of the USGS as the field gradient for a Greater Almond Bluebell Field.
Okay, and if you could go back to Exhibit E. Just had a couple questions on the P&A wells in there. I think several of them are detailed in your cross-section as far as production, but could you maybe give a little background on the productive history of those wells? If they were, it doesn't look, according to the legend, like they were drilled and abandoned, but they had a productive history. And also, could you comment or testify as if you know if they were drilled and shared on a 640 acre or not?
Those wells were drilled during the original one well per section, or 640 acres, back in the 1974 period of time out here. Various operators handled those wells. They were completed in the Wasatch. The bulk of them, except for the well up to the north in section 9, most of them were all abandoned in the late 80s when the price of oil dropped to $9 or $10 a barrel. Completion-wise, they were perforated and acidized within the Wasatch section. Well, in section 17, did do some testing briefly in the Green River out here. The rest of them were just abandoned. A suggestion was made for a well in section 10 to convert it to a water disposal well, but that was subsequently pulled and declined. So all of those wells were drilled and evaluated. They all produced oil, various amounts from the Wasatch section out here. And due to economics in the downturn of the 1980s, they were abandoned or shut in.
Okay, thank you.
Thank you, Mr. Kopp. Earlier you testified as to why you thought it was necessary to infill rather than to downsize in this area. And I'm wondering if you can explain in more detail what wells you're basing that testimony on.
Mainly it's from, and this will come out in the Ms. Ryan's discussion in here. The Greater Almond Bluebell Field geologically was developed originally in the Wasatch with one well per section, and then they allowed a second well per section producing out of the Wasatch out here. And it was done to preserve the pressures in the field, you might say, to better evaluate. As wells were produced, more geologic information, engineering data was from other operators. The recommendation was made for 139-84 to do 4 wells per section rather than 2 wells per section. And I understand the 4 wells per section was proposed because the initial 2 wells that had been drilled in the section were not center of 160s or spaced properly to allow the proper spacing for the 3rd and the 4th wells out here. As you can take a note within our proposed area, the wells that we were playing off from or evaluating were drilled sometimes near the center of the section. And so to maintain a proper spacing of 30 feet between well bores, it's recommended, or we are going along with the original proposal of the 139-84 to drill 4 wells per section and not do a 160 type spacing at the present time.
No further questions.
Questions of the board? Proceed.
A couple questions. Is any of the proposed wells by Badland or your discussions with other operators going to be horizontal, or will they all be vertical?
At the present time, Badlands is working on just a vertical development of this in here. For one, as you know from the cross sections out here, we're looking at 3,000 feet plus of hydrocarbon column out here, and enough wells and enough data is not available to pick a specific target to go horizontal. We feel that the best thing to do at the present time is develop the full resource of these horizons, especially in light of the pressures we have encountered in the deeper Wasatch wells. We do know that operators right adjacent to us, Crescent Point has been mentioned in here, has talked about horizontal wells within the Green River, which they are developing primarily within the lower portion of the Green River, the Uteland Butte member. But at the present time, Badlands has nothing in their thing to do horizontal wells.
If in the future it looks like horizontal wells may be a good idea, could you address how the spacing, how it's spaced today on 640s or 160s would affect that?
As you know from other areas where horizontal drilling is occurring, where vertical wells have been drilled in the past out here, both geologically and engineering wise, you have to evaluate each section or each area then individually, do evaluations for connection of individual zones, take a look at drainage, take a look at the type of completions you're doing for interference of a vertical to a horizontal well. As areas are downspaced, yes, there is always complications of horizontal wells are drilled afterwards to fit the current configurations out here. By going to a 160 type designation, which means you have to stay almost in the center of a quarter section out here, it does not allow for the proper development of these fractured individual reservoirs to be fully developed out here. Yes, at a later date, in the Wasatch section primarily, horizontal wells will have to be evaluated as a total separate entity brought forth as far as spacing and stuff goes. The Green River development is probably going to be a whole different story if you go horizontal.
Okay, thanks.
Any other questions?
I just have one. I'm just curious why there's so much unleased tribal mineral. Is that being pursued, or is it, I mean, is there a reason why it's not leased?
It is being pursued at the present time. That area in there was just one of those areas where the tribe, and there's other in the greater Almond Blue Belt where they haven't leased in the recent times out here. And it was probably one of the reasons why this area was not included in any of the previous spacing order things out here. It's being pursued, and as you know from the letter from the BIA, the tribe, and the BLM, they are in favor of this, which means that they're probably more in favor of a leasing situation.
Follow-up question? Any other questions?
This is just an administrative note. When you were introduced and gave your address, it's different than the address in the exhibit.
Probably, I think the address he gave is Badlands' office address, his business address, and the exhibit is probably,
Just goes to prove we do read the exhibits.
Oh, my home address. Yes, on my resume, I was for a short period of time, I was an independent consultant using my home address. That's probably my fault.
Thank you. Back to the division for follow-up questions.
Thank you, Mr. Chairman. The division would just like some clarification that this is an order only for vertical wells and it's not anticipating these horizontal wells at this time.
Could you address that, please?
Yes.
Okay, back to you. Would you call your next witness?
thank you, Mr. Chairman. I call Deborah Ryan. Thank you. Please state your name and business address for the record.
Deborah Ryan, 730 17th Street, Suite 410 in Denver, 80202.
And who is your employer?
I work for MHA Petroleum Consultants.
And what is the nature of your relationship with Badlands?
I've been providing reservoir engineering support for Badlands since 2012.
And because you have not testified before this board before to establish your credentials, could you tell us about your educational background?
I graduated from Curtin University in 2004 with an honours degree in chemical engineering.
That located?
Curtin University is in Perth, Western Australia. I then graduated in 2008, also from Curtin University in Western Australia, with a master's degree in petroleum engineering. And then in 2005, after I'd completed my coursework for my master's, I started working for Woodside Petroleum Energy in Perth, Western Australia. My role there was in reservoir engineering, production operations for offshore, heavy oil and then gas reservoirs, and also did some time in carbonate reservoirs in the Middle East. I then transferred to Arrow Energy in Queensland, Australia, where I worked as the reserves engineer and then also then as a senior reservoir engineer on the coal seam gas projects in Queensland. And then in 2012, I transferred to MHA Petroleum Engineering in Denver and have been working for them ever since, providing reservoir engineering support, reserves evaluations for clients both here domestically in the US and also still internationally.
Have you testified before, in proceedings before other administrative bodies like our board?
Yes, in 2013, I testified in Idaho for a spacing hearing there.
And Badlands relies on your expertise as a petroleum engineer?
Yes, they do.
I would move that Ms. Ryan be recognized as an expert in petroleum engineering for purposes of this hearing.
Thank you. Division,
No objection.
board members. I just have a question. I didn't know there was any production in Idaho.
A small amount. It's a small gas field.
Well,
Yes.
thank you. All right. Seeing no objections, she is admitted as a petroleum engineer for the purposes of this hearing.
Thank you. Now I show you exhibits A through, replacement exhibits K and L through P. Are these familiar to you?
Yes, they are.
And you prepared them?
Yes, I did.
All right. Tell us about exhibit K, please.
So as it's been discussed, Badlands is looking at developing the application area, which is outlined by the red outline on this map, with vertical wells that will be initially completed in the Wasatch Formation and then recompleted into the Green River. So in order to come up with type curves to test the economic viability of this development, we have looked at where wells both in the application area and directly offsetting to the application area have produced in either the Wasatch alone or have been commingled Green River Wasatch wells to establish a type curve. There are 3 wells that have been used to look at the Wasatch only initial production, or the QI initial rate. 2 of those wells sit within the application area and have been recently drilled by Badlands Energy, the Bab and the Cutch well, which are indicated with the yellow box with the red outline. The other well that we've looked at is blown up on the inset in the top of the exhibit, and it's the 2143 well up in the north. This well is a Wasatch-only producing well and has been producing from the Wasatch since it was completed. And we used this well specifically because it offsets Wasatch number 9, which is the blue well circled just to the south of it. This is one of the early Wasatch-only production wells from the 1980s within this area, and this well is still producing from the Wasatch Formation and has been doing so since that 2143 well came online. The other wells that are designated on this map are Green River Wasatch commingled wells, and they are indicated by the red diamonds, both to the west of the application area and to the north in the inset that's blown up as well.
And exhibit L. Tell us about that, please.
So this takes the initial rate from the 3 wells that are completed in the Wasatch only, as I indicated, The solid red line is the initial peak rate that came out of the 2143 well, which, as I pointed out, offsets a Wasatch-only producing well within the field. The Cutch and Bab wells, which are very recent completions by Badlands Energy, are then shown by the blue and purple lines. These wells are actually still in the process of cleaning up, and we don't have, for Cutch, we just have the first month of data. And the Bab well, when these exhibits were put together and revised last week, we still only have 26 days of production for that well. As you can see, the Cutch is starting to level out at the same rate as the 2143 well, and the Bab well is actually much higher than that, and actually from recent production data in the last couple of days is actually going even higher. The rate that we've then used to determine a type curve sits just below that. We've used a 450 barrel a day initial rate assumption, which is indicated with the dashed grey line on the chart.
And a point of clarification, in the initial request for agency action, I think the spud date for the Bab well was listed as a date in June 16th, I believe, but that was not correct. Is that the well was spud in a different date?
The spud date, I'd have to defer. The Bab well was spudded in July. The completion date of it, once it was fracked and brought online, though, has been in August.
Thank you. And now Exhibit M.
So the first graph that I want to point your attention to is in the lower bottom corner, and this is the culmination of all the production from the Green River and Wasatch commingled wells. The production from those individual wells is shown by the black lines that show how that stacks up over time. The blue dots on that graph is the average of the production rate coming from those wells, which, as we get less and less wells online, changes quite dramatically. So in order to fit a type curve through the commingled portion of those wells, we've matched with the green line the early rate and decline of the wells when there is a large well count, and then extrapolated that decline with the green line. What we've then done is, when you look at the main graph, which just shows the single type curve, we've taken the initial rate that was determined from the Wasatch-only producing wells, declined it over a 2-year period, and then when the wells are going to be recompleted into the Wasatch Green River, use the decline curve parameters from the commingled wells that I've shown you to extrapolate out the type curve. The individual type curve parameters for the Wasatch only and then the Wasatch Green River production are shown in the yellow box with the initial rates and decline parameters. This type curve equates to an EUR of 319,000 barrels, and a GOR has been assumed of 0.5 MCF per barrel, which is consistent with the reservoir fluids within the Green River and the Wasatch.
Exhibit N, please.
Using the EUR from the type curve that we determined in the previous exhibit, we've looked at what this means in terms of a drainage area for these wells. So using the 319,000 barrel EUR estimate, the net thickness, porosity, and water saturation values have been determined from the logs drilled by Badlands in this area. We've then looked at what the formation volume factor is for the fluid that we know is produced from the Wasatch and the Green River, and we've estimated a recovery factor. This equates to a drainage area of 62 acres, which we know is not greater than the 160 that's an approximate to the 4 wells per section.
And your conclusions are Exhibit O.
So using the type curve that we determined, we then ran economics to determine that the development of the 4 wells per section would be viable. The expense assumptions are outlined under the costs bullet. The $5.6 million cost for drilling and completions is consistent with the recent AFEs that Badlands have had for their recent drilling and completions. And then the operating costs of $4,336 per month and a water disposal cost of $0.295 per MCF are from Badlands lease operating statements and expense reports. We ran the type curves at a WTI strip and a Northwest gas, a gas price from the Northwest Pipeline as of September 2015, with all the appropriate corrections for the received price that Badlands gets in this area. And what we find is that the PV10 of these wells at these economic conditions are greater than 0, and therefore we believe the development and the type curve is economic at the current conditions.
And now Exhibit P.
So in conclusion, the Wasatch and the Green River type curve has been created from offset well information within the application and offset areas. The drainage area of the current wells is not greater than the 160 acres. Wells are economic at current market price conditions. The lands offsetting the application areas to the north, east and west have previously been authorised for 4 wells per section. There's no known reservoir engineering differences between the application lands and the offset and adjacent lands. And the proposed well density will prevent waste, maximise recovery of the area and protect correlative rights.
I have no further questions.
Vision?
Thank you, Mr. Chairman. Mr. Doucette does have a couple of questions for the witness.
Yeah, Dustin Doucette again. On Exhibit K, if you could go there. On this, you only used two wells for, and they were Wasatch only, is that correct, in your analysis?
We actually used 3. So we used the 2 wells within the application area, which have got the boxes around them, and then up in the blown up inset, which is up in the top right corner, the 2143 sits just north on the eastern side of that, and we used that one as well. That was the flat line, so it was an average daily rate from the peak production when that well was brought online in the early 2000s.
But you only used the 2 wells, though, in the subject area, or subject lands, is that correct? Within the
I guess we used 2143. We did use that in the type curve with what kind of average QI we were expecting, for this one. So when we put this together initially, we didn't have the Bab well production, and we only had the Kutch and the 2143. So we combined them, and then we included Bab onto this once it came online, and we revised the exhibit. The average rate is actually of all 3 of those wells.
So if I got this right, based off, I think, Exhibit E, you've got 3 other producing wells in the area, aside from
So
the 2 you use for Wasatch only?
Within the application area, Badlands has drilled 4 wells. The first well that was drilled in Section 24 is the Papadakis well. That well is actually only completed in the Green River and the very top portion of the Wasatch, so it's not analogous to the deeper Wasatch that's overpressured. The Tryon well that was drilled and added to exhibits, the cross sections that Rick presented, that well has been drilled and perforated, but it has not been fracked and it is not yet on production, so there is no production data from that well at this stage.
And what about the 4 P&A wells in the subject lands? Is there a reason you didn't use those in your analysis?
We reviewed all the completion methods that we used throughout the history of these. It's also why we didn't use the Wasatch number 9 well. A lot of these wells were not fracked. There's a history of perforating and acidizing, even though they were completed in the Wasatch, and we wanted to make sure we had consistent completion comparison for rates as well as reservoir.
But you feel the ones you did use are relative to the subject area then?
Yes.
On Exhibit O, you mentioned a PV10 of greater than 0. Do you happen to know in your analysis what that?
I can't remember what it is off the top of my head, sorry.
Okay.
Back to Exhibit L or O?
It was O. And the question was just on the PV10 number, if she knew what that actually was.
And I don't remember what that is.
That's all the questions I have. Thanks.
Back to you, Ms. Miller. You have a question?
Sorry, Mr. Chairman. John Rogers does have a question.
What is the reasoning behind not completing the Green River immediately and waiting a period of time?
The Wasatch is actually overpressured. We've seen that consistently from offset data. The Wasatch 9 well that I actually showed that was drilled in the 80s had a pressure survey, and it shows clearly that the Wasatch zone is at a higher pressure than the rest of the Green River. There is also actually two different types of oil. The Wasatch generally has a yellow wax, which has a slightly higher GOR, and then the Green River has a black wax. So part of it is to deplete the pressure and make sure that when we commingle the wells, the zones are at a similar normal pressure. And then also part of the getting some of the yellow wax out before it's commingled and combined as a black wax mix.
Do you find that there's no reservoir damage to the Green River if you wait that period of time?
We haven't had any experience with that in terms of seeing any reservoir damage from waiting to come in and frack that well. Badlands has some experience in other parts of the basin working with that, and we haven't had issues with it, no.
I'm going to ask the board if they have any questions. Board members, do you have any questions? Okay, Mr. Moon.
Yeah, go back to Exhibit K. The drainage area, you said, is approximately 62 acres. And so my question just goes back to the question we've had already. Why not space 160 versus increased density? Where in general, a drilling unit may not be smaller than the maximum area that can be efficiently and economically drained by one well. So it can be spaced larger, it can't be smaller, of course, so we can go and it is, right now it is 640, correct? So it would be down spacing if we did it, but it just seems where we already know that that one well is not going to drain 640, and it's even going to drain less than 160, why wouldn't we downspace this to 160? Looking to the north of this township, to the east and to the south, it appears that wells have been drilled on a 40-acre to a 80-acre basis. Basically, it's taking that many wells to drain that reservoir. Why would we start with larger? Because we can, space back up to 640. But once it's 640, we can never go smaller once wells have been drilled and shared on a 640 basis. Why start large? Why not start with what we know the pool is?
So the calculation to look at drainage area, there's a lot of uncertainties built into that. And both from an EUR and recovery factor particularly are very unknown in this particular area. And any changes to that would change the volumetric calculation. What we're trying to demonstrate with that is that we're definitely not believing that we're draining anything bigger than kind of like a 160 at the moment. But even by changing the recovery factor to a 5%, it increases that spacing up to nearly 90 acres. So there's a lot of uncertainty in some of those parameters. And as Badlands get more experience in the application area and we can have a look at thicknesses and saturations as the area is developed, then understanding how drainage is affecting and particularly running pressure logs, then figuring out the exact spacing in terms of the downspacing would be much better defined. So.
And I would also point out that correlative rights would be affected negatively. This area has been developed historically since the 70s on the basis of 640 acres. If everyone to the north, to the west, and to the of the subject lands shared on a 640 acre basis, that seems. Why should these lands be different? Why should?
Well, to the south, it's 40-acre spacing, correct? Just to the south.
And to the south, it's the general well siting rule applies. So wells could be drilled on 40 acres.
And shared on 40 acres.
And shared on 40-acre basis.
Okay.
But as again, historical development in this area has all been on 640s. And
Here's we're kind of in that medium area. To the north, it's 640. To the south, it's 40. And do we have 160 acre spaced areas anywhere in general?
Gordon, we just southeast of this property, we approved a pilot on 80 acres, and we haven't gotten a report back yet on how that's going, but that's probably the closest place where it's been done.
And again, as Mr. Kopp pointed out, a well in the middle of an 80-acre may not be the desired location based on the geology and the technical data available.
I see the division discussing this. Is there anything you would like to share with us on that? So the conclusion that we're kind of reached, one of the primary factors in going to remaining 640 is the flexibility of well locations in this potato chip bowl, potato chips type formation. Is that what your testimony is?
Yes, Mr. Kopp informs me, yes, that is.
And the con to that, the downside of that is that there are additional leases that would be held by production that you wouldn't have on a 160. And as you balance those wells that can be located optimally versus the leases that are held by production, you got to have the wisdom of Solomon, and that's what we're here for.
Yeah, from a royalty owner's perspective, one well in this section that's space 640 holds that forevermore. And so that's obviously the producer desires. And so I think we need to have, good justification for that. And yeah.
So, okay. All right, then back to you, Ms. Miller. I believe that concludes
Yes, sir. It concludes my case in chief.
And let's deal with the exhibits then, if we could.
I would move that exhibits A through F inclusive, revised exhibits G through J, and replacement exhibits K and L, and exhibits M through Q, and exhibit Z as supplemented be admitted into evidence.
Division?
The division does not object.
Board members? Seeing none, all of those exhibits as revised and substituted will be admitted.
Thank you, Mr. Chairman.
Okay, we're now to the division.
Thank you, Mr. Chairman. If the division could have about 5 minutes to discuss this matter and their position on it.
This is a perfect time for a 10-minute break.
Okay, thank you.
Are back on the record. Ms. Reynolds?
Mr. Chairman, members of the board, I'm going to turn the time over to John Rogers to explain the division's position on this question.
Chairman Gill and the board, we, after discussing some of the issues here, some of the issues Mr. Moon raised, we thought about, and as we look at those sections that have had wells drilled in them, they obviously need to remain at 640. There are several other sections that have not had wells drilled in them. And the thought is, well, do you space those at 160? But discussing this with internally, we think to remain consistent throughout the area, to address surface issues and have the flexibility to drill where they need to drill out there, we recommend that they go with the 640 spacing.
Thank you very much. That was very helpful. Okay, anything else for the division?
No, nothing further.
Okay. Any board questions of the division? Then we're back for summation.
Thank you, Mr. Chairman. I would thank you all for your time and attention and consideration today. I would again reiterate our request that this be approved for 4 wells per 640 acres. And with that, I would opine that Badlands has met its statutory requirements and request this request be approved.
Board members, would you like to adjourn and discuss this, or are you ready to make a motion?
Anyone want to continue that?
Hey, we'll be in recess for a few minutes.
Yes, sir.
Okay, we're back on the record. We'll take a motion at this time.
I move that we accept.
You're not speaking into the,
Oh, forgive me. I've almost lost my voice, Julian. I move that we accept the petition to space this area at 640 acres as requested.
Or to increase density to
Increased
four,
density.
4 wells per.
Thank you, Gordon, for that correction.
And I'll second that motion.
okay, any discussion of the motion? I'm going to restate the motion. The motion is to approve the request for agency action as written. All in favor of that?
Aye.
Any,
Aye.
any opposed? Let the record show that that was unanimous. Ms. Miller, will you please prepare the order?
I will do so.
Yes.
Thank you.
Council, thank you very much. We're now to agenda item number 3, docket number 2015-027, cause number 166-06, in the matter of Fidelity Exploration and Production Company. Give me a second to get organized here. Okay, we'll take appearances of counsel at this time.
Fred McDonald of McDonald and Miller on behalf of Petitioner Fidelity.
Steve Alder, the Utah Attorney General's Office, on behalf of the Division of Oil, Gas, and Mining.
Okay. Just so that we're clear on this matter involves exhibits that are confidential and proprietary. If at any point in the discussions we are getting into matters that any party feels is confidential or proprietary, we would ask you to stop the hearing, approach the board, and let's get that resolved before we get into any troubled areas. With that, Mr. McDonald.
Thank you, Mr. Chairman. With me today, we have Mr. Wes Adams, who's the landman. We have Mr. Dave List, who's the senior geophysicist and geologist, and Mr. Chuck Mabey, who's the senior petroleum engineer for Fidelity. I would ask that they be sworn in as witnesses at this time.
Raise your right hands, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
The record reflect that all 3 witnesses said yes. Ladies and gentlemen of the board, the resumes of all 3 witnesses were submitted as part of Exhibit A in this cause. Mr. Adams will be testifying, however, only as a fact witness. I'd like to note that Mr. List's resume indicates that he has been qualified as an expert in both geophysics and geology before the Wyoming Oil and Gas Conservation Commission. If the witnesses were separately and individually asked about the contents of their respective resumes, they would all confirm the material shown on those resumes. Based on Exhibit A and with the presumed stipulation of the division, I would ask that Mr. List and Mr. Mabey be recognized as experts in geology and petroleum engineering for purposes of this cause.
Division?
Mr. McDonald, have either Mr. List or Mr. Mabey been testified as experts before this board?
Not before this board.
And Mr. Chairman, then I think that we probably have the time, and it would be helpful to the division and I think to the board to have their resumes summarized before the division stipulates by the witnesses. I think some testimony from the witnesses as to their experience is helpful in that regard.
I think that we agree with that.
All right. We'll do that then with each witness. I'm assuming, Mr. Chairman, by your preference that the board has granted the motion we filed for in-camera review of exhibits K through O.
Yes.
Right, thank you. Again, what we intend to do is that we will offer testimony about those exhibits, but they will not be displayed or made available to the general public. I also assume that the board has Exhibit E2, which was an additional exhibit that was filed on Monday. I do know that the motion for leave was granted on that.
Yes, I've signed that order.
And with respect to that, I do want to apologize to the board members for the kind of piecemeal approach with some of these exhibits. I won't go into the details, but it was kind of a perfect storm of events that caused that to happen, and I do understand the way that you view these and all that. So if there's any point that you need time to be able to call those exhibits up, please let me know. Finally, also, that I want to confirm that you received the supplement to Exhibit Z, which was just the mailing receipts. That was filed on Monday as well.
Yes.
All right, thank you, Mr. Chairman. As the board is aware, Fidelity is the operator of the Cane Creek Federal Unit located west of Moab and north of Dead Horse Point. All depths in that unit are unitized, but currently there are two separate participating areas, the largest being the Consolidated Paradox Formation participating area. In February of 2013, Fidelity spud the Cane Creek Unit 7-1-26-20 well, which we will sometimes refer to as the 7-1 well, and drilled it horizontally in anticipation of oil production from various clastics in the Paradox Formation. The well was completed as a producing oil well with first production on January 27, 2014. However, the well does not meet the unit paying quantities definition contained in the governing unit agreement, and therefore production is not allocated on a production or participating area basis. Instead, production is allocated on a wellbore basis unless and until the well should produce in unit paying quantities. Since the 7-1 well is a horizontal well, the lateral of which extends through 2 federal leases, a communitization agreement is required to allocate production on a wellbore basis. However, the BLM, which is the lessee and administrator here, will not approve a communitization agreement without a conforming spacing order from the board. That's the reason we're before you here today. We're asking for a creation of a special drilling unit for this particular well. It's important to note that the general horizontal drilling rules, and in particular the rule establishing a temporary 640-acre drilling unit for horizontal wells, do not apply to lands within a federal unit pursuant to Utah Administrative Code Rule R649-3-2 subpart 8. As the testimony and evidence will reflect, the Paradox Formation is a complex conglomerate of resource-bearing clastics interbedded with salts. Due to these complications, the Bureau of Land Management, as administrator of the Cane Creek Unit, has consolidated the entire formation when establishing the participating area. For similar reasons, Fidelity believes the entire Paradox Formation constitutes a common source of supply. In addition, Fidelity and the Bureau of Land Management have agreed, based on the same evidence and with the in-camera exhibits offered today, that the appropriate drilling unit should be the lands as outlined in the request, with a 660-foot setback from other wells, both laterally and vertically. Fidelity is confident that no lands beyond those being requested for inclusion in the drilling unit are being drained. Although not specified in the request, Fidelity is also requesting that should the 7-1 well ever produce in unit-paying quantities, or if the requested drilling unit lands are otherwise brought into the unit participating area, the requested drilling unit, if approved, will be suspended, the conforming communitization agreement terminated, and the unit agreement will then govern production allocation pursuant to that participating area. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-5 subparagraph 3B and 40-6-6 subparagraph 6. The request was sent via certified mail, return receipt requested to the Bureau of Land Management with both the state and Moab district offices as the governing agency and oil and gas owner administrator, and to all overriding royalty interest owners in the leases covering the subject lands, to their last addresses as disclosed by a search of the BLM and Grand County Realty records right at the time of the filing of the request. Fidelity is the sole operating rights owner. Notice of the request and of this hearing was also published in the Salt Lake Tribune and Deseret Morning News on October 4th, 2015, and in the Moab Times Independent on October 8th, 2015. The Utah State Office of the Bureau of Land Management timely filed a letter with the board on October 14th, 2015, expressing its support for the granting of the request. To the extent that that letter is not already deemed part of the record, we request that the board consider it to be part of the record. No other objections or responses were filed, and the division elected not to file a staff memorandum in this cause. With that, I'll commence my examination of Mr. Adams. Mr. Adams, please state your name and business address for the record.
Wes Adams, 1801 California Street, Suite 2500, Denver, Colorado, 80202.
What is your current position with Fidelity?
Landman, that's including responsibilities of Northern Records for the Paradox Basin assets inclusive of the Cane Creek unit.
All right, for purposes of the record, would you please state the corporate and bonding status of Fidelity?
Yes. Fidelity is a Delaware corporation with its principal place of business in Denver, Colorado. It is a duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. Fidelity is an indirect subsidiary of MDU Resources Group, INC.
Okay, can you just give the board just a very brief outline of the history of the Cane Creek unit?
Yeah, the Cane Creek unit was originally formed in 2002. All formations are unitized. Currently, the unit encompasses 53,474 acres. There are 2 participating areas, the largest of which involves a consolidated paradox formation. Currently, Fidelity serves as unit operator.
Okay. I'm going to now show you what have been marked as Exhibits B and C for purposes of this cause. There's, Exhibit B is currently shown on the PowerPoint presentation. Do you recognize these exhibits?
I do.
Were they prepared by you or Fidelity or my law firm personnel with your input and review?
They were.
Okay, turning your attention to Exhibit B, would you please explain to the board what it represents?
Yeah, Exhibit B is a general reference plat location of the Cane Creek unit, which is due west of Moab, north of the Dead Horse Point and Canyonlands. So I think you can see off of to the right of the unitized area, we have Moab indicated in black font. Our red lines on this map indicate our boundary lines of the current Cane Creek unit, of which we have the 53,474 acres encompassed. The green lines on this exhibit do show the participating areas. The participating area up to the north is indicated as our participating area C. That is stemming from our predecessor as well as an initial PA of a Cane Springs federal unit. Down to the north, we have our green lines, which indicates our current participating area. It's a second consolidated paradox formation participating area. The blue lines within the exhibit do show the proposed spacing area which we are discussing today. One thing I'd like to add about the second consolidated participating area is something that Dave List will talk about, but it's due to the geologic complexities that we have a common source of supply to which the entire paradox formation is a single PA for royalty purposes that the BLM has concurred with.
Okay, now directing your attention to Exhibit C1, which is shown on the PowerPoint, please explain the board and its significance.
Okay, C1 is again indicating just our spacing unit. This is a zoomed in of the exhibit of the captioned area. So we are looking at the second consolidated PA outline in yellow. In the red is showing our unit boundary lines, and the blue does show the 712620 spacing unit, which we're asking for today. Within this depiction, we do see the surface hole location in green, followed by our landing point on Clastic 1819 and a bottom hole location in Clastic 21. Perforations are located between Clastic 1819 and 21.
All right, and this lateral crosses 2 federal leases, is that correct?
That is correct. As depicted, it crosses federal leases UTU 53626, if you can see that on the map, and 64821.
Okay, now directing your attention to what has been marked as C2. There's not a PowerPoint for this. Again, please explain to the board what C2 represents.
Yeah, C2 is a listing of all production interest owners in the 2 leases compiled from title opinions with Fidelity, Paydex, and the update from BLM lease and unit records by Vern Jones and the Grand County Realty records by Geoscout Land Title Company.
And is there a uniform royalty owner then?
Yes, the United States is the royalty owner. Fidelity is the only operating rights owner.
Okay, can you please provide to the board just a brief history about the 7-1 well?
Sure. The 71-2620 well was spud on February 21st, 2013, drilled horizontally through the Paradox Formation Classics and completed as a producing well, with first production achieved January 27 of 2014.
Now I'm going to direct your attention to what has been marked as Exhibit Q for purposes of this hearing. Do you recognize this document?
Yes, I do.
Is it an official business record of Fidelity
Yes.
relating to the Cane Creek unit?
Yes, it
Okay,
is.
please explain to the board what this is.
This is the October 22nd, 2014 letter received from the BLM indicating the Cane Creek Unit 712620 well, under existing conditions, was not capable of producing unitized substances in paying quantities. As defined in the Cane Creek Unit Agreement, in other words, no participating area will be established for the said well. The letter also confirms that because the lateral of the well produces from 2 federal leases, a communitization agreement will be required, and that a conforming order from the board establishing a drilling unit is required prior to agency approval of a communitization agreement. The letter also indicates Fidelity could petition to have the lands declared as necessary for unit operations and included in the PA. Fidelity initially sought to do this, but Sitla did object as an owner in the existing PA, and so this alternative was dropped from the consideration. The requested order is therefore required to protect the correlative rights of the overriding royalty interest owners in each lease. The effective date of the order should be correspondent with the first date of production, January 27, 2014, not only as a matter of equity and fairness, but also because BLM guidelines require so.
Okay, can you confirm what will Fidelity do with the proceeds? How are they going to be paid then?
Fidelity will retroactively pay production proceeds on this order based on the board from the date of first production.
Okay.
Confirming that we will, if order is granted, would be suspend the well and, excuse me, if we move on, and if this well is actually ever determined to give a unit paying quantities, we would ask that this order be suspended and lands within the proposed drilling area, otherwise be included in a participating area, so as to allow the terms and allocation scheme under the unit agreement to control. The inconforming CA will also contain a provision providing for termination of this.
Okay. I'm going to turn your attention now to the certificate of mailing. In this cause, this was a pleading that was prepared by my office. And there's a bunch of names and addresses listed on that and an exhibit to that. Do you recognize those parties?
Yes, I do.
And who are they?
Those are the interest owners that we discussed and provided by McDonald and Miller through the notification.
And how were those names and addresses compiled again?
Through Fidelity Land Records, BLM State Office Records, Vern Jones, and GeoScout Land Title Company.
Okay. Directing the board's attention to Exhibit Z, it's supplemented. These are true and correct copies of the return receipts or the return mailings received by my office of the mailings of the request, supplemented Monday to reflect the additional receipts returned after the exhibit filing date. With that, Mr. Chairman, that concludes my examination of Mr. Adams.
Mr. Elder.
Thank you, Mr. Chairman. Mr. Adams, looking at Exhibit C1, can you, for my benefit and the board's, indicate where the boundary of the participating area, that gold line, goes with respect to the spacing request?
Yeah, so I think to answer the question, we share a common boundary line beginning in what's going to be the northeast of Section 7, continues up to the bottoms of our contiguous sections above. So we have, it's hard for me I could point for you.
Let me try and get a
Well, would it be fair to, so the south boundary of the spacing area is the same as the north boundary?
One and the same. It's a common boundary line through the south of the proposed 712620 in blue. The only lands that are new are to the northeast, correct?
And so what does that mean, the participating area? Does that mean all of the owners within that gold area share production?
That is correct. They are all sharing in production to the entire compassed area, which is 9,280 acres approximately, proportionately reduced to their interest.
And hypothetically, if this request for establishing a spacing unit for this well were to include a quarter section of that participating area, what would the consequences of that determination be for the participating area owners?
Okay. So we would have to look at an allocation measure based on the acres that are shared from the participating area to that of the spaced area. In question, there may be a 40-acre section northwest of the northeast, for example, would be proportionately reduced by the 40, contributing to both the spaced area and to the participating area. That requires a division order interest that gets rather complex.
Could you be more specific? What do you mean by rather?
So in order to allocate the 40 acres to all the participating area interest owners, you have to give them a 40-acre allocation to the CA and to the PA. So it requires a division of interest internally for interest owners, which is more complex in nature. I don't have the amount of owners that are in the current participating area, but it does require a separation of that interest. There are interest owners to the participating area that are not in the spaced area. They would also have to be taken into consideration when this division takes place. Other royalty owners, state of Utah, as an example.
So the SITLA objections were based on, do you know what their objections were based on?
Their argument stemmed from dilution to the well, which is a non-paying quantity as well. Therefore, to be diluted by a well that wasn't unit-paying quantities and was not a just decision in their minds for equality of wells production.
Okay, and talked about suspension in the event that this well does produce in paying quantities. First of all, is that a likelihood, or how would that be determined that it was in fact paying in paying quantities?
So if we were to re-enter the 7-1 2620 and any horizon within the Paradox Formation that has been consolidated, we would have to recover production that is in paying quantities enough to cover the cost of drilling and completion and a reasonable profit. If that decision was made, if the economics supported that operation, then we would ask for a revision consistent with prior PA revisions in the area. So what we would ask is, given new science, if we had the potential to propose such an operation, that we would not preclude these lands from becoming part of the participating area as a consistency issue. In which case, I guess to further support the interest owners of the participating area, there would be no objection because the well would receive a paying quantities determination. All the wells within the participating area have received a paying well determination. So when you're being diluted by a well that has received economic quantities, the risk is considered acceptable. It's considered fair, if you will, versus if you have a well that's diluting the participating area that has not received paying quantities, it's not of the same merit. So the well is not of equal production. Therefore, the dilution may or may not be to the benefit.
I think I understand that, but I guess what I heard you say is that there would have to be a re-entry, or is it possible that just over the lifetime of this well, it would convert from non-paying to paying quantities?
If I understand the question correctly, I do not believe that the current well in its state of production would ever meet a paying quantities determination. It would have to have future operations, whether it's a recompletion or a re-entry.
Okay, and so I guess my question about the suspension and the nature of the order that the board is being asked to enter is, and maybe your attorney will need to help with this, but will you come back to the board, or will it happen automatically upon a successful recompletion? How do you anticipate that conversion from, or the suspension of this order to take place?
It would be subsequent to any type of operation that changes the material facts that we're talking about today. I think that we want to reserve our right to allow a PA revision in this well should it ever come to fruition.
Mr. Chairman, maybe if I can help with that, Mr. Alder. In previous situations similar to this and other units, the order was written that if that was ever to be determined, it would be by operation of the BLM's determination of a paying quantities well, then it would be suspended and notice would be given to the board secretary to indicate that the order would be suspended at that time. That's how it was handled in previous matters.
Thank you. Mr. Rogers has one question, if that'd be appropriate, Mr. Chairman.
Proceed.
Mr. Adams, you stated that if this well if it would go back to the original date of first production royalty payments, would that happen on all the interest payments would have to go back to the original owners and refunded on a unit basis, or would it come back? I just understand when you had to go back to first production. What did you mean by that?
Sure. So what we do is we take production we take our production data from the first production, and we go in and we reverse and rebook based on each owner's interest in this proposed spacing unit. So I think we have a 357-acre spacing area encompassing 2 leases. So each owner's proportionate share in each lease would then be reduced by the whole. Their share of that lease would then be paid to them. That would be to the overriding royalty interest owners. So we do it retroactively in order to incorporate production as it should have been from day one without a spacing order. So
it's as if the well was never in the unit.
Yes, so correct.
And how does that work if it went like we were arguing about a little bit before? What if it went back in the unit? Do you make those calculations back if the well happened to go back in the unit?
That's correct. So then we would make an adjustment to first production of which operations created a paying quantities well. And we would make a similar adjustment to the new deck depending on their interest in the whole.
That's all the questions the division has of this witness. Thank you.
Board members? Seeing none, we're back to you, Mr. McDonald.
Okay, Mr. List, please. Mr. List, would you please state your name and business address for the record?
David List, 1801 California Street, Suite 2500, Denver, Colorado, 80202.
What is your current position with Fidelity?
I'm a senior geophysicist with Fidelity and mainly working in the Paradox Basin currently.
Right. In response to Mr. Alder's request, would you please provide a brief summary of what your education?
In 1984, I received an undergraduate degree in geophysical engineering from Colorado School of Mines. And then again in 1995, I obtained a Master's of Science degree from Colorado School of Mines in geophysical engineering also.
Okay, and a brief summary of your work experience, and particularly in geology?
From 1984 to 1990, I worked for Home Petroleum in Denver, Colorado, working the Williston Basin as both a geophysicist and a geologist. And then from And then from 1995 to 2000, I was a senior geoscientist for GeoQuest Reservoir Technologies in Denver, Colorado. There I was mainly involved with developing reservoir models, geologic reservoir models. And from From 2000 to 2007, I was a senior geological consultant for International Reservoir Technologies in Denver, and in that position, I was a part owner, and we did consulting projects all across the world, Middle East and South America mainly. And from 2008 to present, I've been a senior geophysicist with Fidelity Exploration and Production in Denver, Colorado.
And your work with Fidelity includes this Cane Creek area, right, the Northern Paradox area?
Yes, it does. I've
Okay.
been working the Paradox for Fidelity since I started working for them.
Okay, and then you've also published numerous papers on geophysics, geology and geophysics.
Yes, I have.
Okay, geophysical information, right? And you also, again, to confirm, you've been qualified as an expert in geology before the Wyoming Oil and Gas Conservation Commission?
Correct.
Mr. Chairman, at this time, and Mr. Alder, if that satisfies your request, I would request that Mr. List be recognized as an expert in geology.
Thank you, Mr. McDonald. I think it's helpful to put some flesh on the resume, and I appreciate its expertise. Thank you. We have no objection.
Board members? Then Mr. List will be admitted as an expert witness in the area of geology and geophysics.
Thank you, Mr. Chairman. Mr. List, would you just provide a very brief overview of the paradox formation in this particular area, the Cane Creek unit?
Yes, the Paradox in the northern part of the Paradox Basin is a fairly thick, in our area here, 3,500 to 4,000 foot interval of interbedded, what we call clastics with organic content and hydrocarbon bearing with evaporite, salt, and potashes. It's a very complex. There's a lot of salt tectonics. There's a lot of basin tectonics, which has created fractures within the clastics in the Paradox Formation. It's extremely faulted also. So basically where our best wells are is where we encounter open natural fractures, and that's our challenge.
I'm going to show you now what have been marked as Exhibits D through F for purposes of this cause. Do you recognize all these exhibits?
Yes, I do.
And they were prepared by you or Fidelity personnel with your input and review?
Yes, they were.
Okay, directing your attention then to Exhibit D, which is shown on the PowerPoint. Please explain to the board what this represents.
Exhibit D is the wireline log that we recorded in the 7-1 pilot hole. We drill a pilot hole first, a vertical hole, to find the formation of or layer of interest, and before we go horizontal. And this is mainly just the logged portion over the Paradox Formation, starting at about 3,800 feet measured depth down to a total depth of around 7,900 feet. This is about 200 feet short of the base of the Paradox. So this makes the Paradox Formation at the 7-1 location about 4,000 feet. It also shows the nomenclature which we use within the Paradox. At the top of the Paradox, we typically encounter our first salt. That would be considered salt 1. Beneath the first salt would be the first shale, shale number 1, or classic number 1, and then all the way down. And by the time we get down to the interval that's producing in the 7-1, that is classic 21, also called the Cane Creek Shale. There's approximately 26 of these clastics encased in the salt, and most of these have organic material that have been converted into hydrocarbons, making virtually all of them prospective, most notably the Cane Creek Shale.
And this, again, this is the log from which the stratigraphic definition of the Paradox Formation, as we've used in the request, came from. Is that correct?
That is correct.
Okay. Directing your attention now to what has been marked as Exhibit E originally and is actually E1. It's shown on the PowerPoint. Please explain to the board what this represents.
This is a structure map that's made on top of Clastic 21, or the Cane Creek interval. And it was made from the existing well control shown on this map, along with 3D seismic. So it's fairly accurate. What it shows is how structurally complex the Paradox is at the Cane Creek level. There's over 2,000 feet of elevation change from, for example, the 2-1 on the western side of the map up to the northeast corner. It also shows the black lines on here are the mapped faults that we've interpreted here. And what you can see is you can see numerous mapped faults here. So the combination of this incredible structural complexity, the faulting, produce erratic patterns of fractures within the Cane Creek, and they're difficult to predict. And also it's almost virtually impossible to map concisely any sort of compartmentalization that may be occurring. The larger faults are probably compartmentalizing laterally within the Cane Creek Formation, but they also may be providing some vertical conduits for fluid movement. Also shown on here in the 7-1 horizontal well in the middle of the picture here, you'll see some red intervals highlighted, and that's where the 7-1 has been perforated. Also shown is a cross-section, which I'll show next, that starts out from the Cane Creek Unit 1-1 that produces from two clastics above the Cane Creek, the clastic 1819, the 12-1, which produces from the Cane Creek interval, the 7-1, which also produces from the Cane Creek interval and possibly the clastic 1819, and over to the right, the LC1 or the Long Canyon one, which produces both from the Cane Creek and the clastic 1819.
And then directing your attention to Exhibit E2.
E2 is the cross-section, which I just explained. And it has highlighted on here all the clastics down to the Cane Creek clastic 21. So you can see there's 21 clastics down to the Cane Creek 21. The ones that are highlighted on the right are the thicker clastics and what we believe are the more prospective clastics for future hydrocarbon production. Also noted on here are just some of the salt layers. And what I'm kind of trying to show here is there's some extreme variations in the salt thickness. For example, if you look between the 12-1 and the 7-1 at salt 18, that interval almost doubles in thickness between those two wells. Well, this is caused by salt tectonics or movements of the salts within the formation after deposition. And again, this could easily create the open natural fractures in the reservoir.
Okay, directing your attention then to Exhibit F, please explain to the board what this represents.
Exhibit F is the diagram of the 7-1 lateral as it was drilled. And you can see there labeled the Cane Creek clastic or clastic 21. And over on the left-hand side, you see the vertical pilot that was drilled to obtain the depth information. And then we kicked off or sidetracked from the vertical hole above the clastic 1819, drilled down, built a curve, landed within the Cane Creek interval. Approximately 2,000 feet into the lateral, we hit a severe dip change, which caused us to drill out the top of the Cane Creek layer, and we drilled into the salt. And then approximately 1,500 feet or 1,000 feet later, we encountered the Cane Creek again, and we were able to steer the well within the Cane Creek to the total depth of 11,941. Also shown on this figure are the perforated intervals. You can see that we have two large intervals of perforations within the Cane Creek. Later on, we came up and added perforations into the 1819 clastic.
So is it your expert opinion then that the Paradox Formation constitutes a common source of supply for oil and associated gas and hydrocarbons?
Yes, it is.
But that there is compartmentalization that is difficult to predict?
Correct.
That concludes my examination, Mr. List.
Thank you. Division?
Division doesn't have any cross-examination for Mr. List.
Board members? We're back to your next witness.
Maybe please state your name and business address for the record.
My name is Charles Mabey. I work for Fidelity E&P Company in Denver, Colorado, 1801 California Street, 80202.
And what is your current position?
Sorry, is that better?
What is your current position with Fidelity?
I am a senior petroleum engineer responsible for reservoir production operations and facilities for the Paradox Basin.
And that includes the Cane Creek unit?
Correct.
Okay. Would you please provide a brief summary of your education?
I earned a petroleum engineering degree, Bachelor of Science, from the University of Wyoming in 1985.
Okay, and then what has been your work experience since graduation?
So for the past 30 years or so, I've been working mainly upstream oil and gas, production, drilling, completions, reservoir, reserve analysis for a lot of different companies. I started with Fidelity in May as the primary reservoir engineer for Paradox and also to take care of production operations in the field. I've had experience in most every basin in the United States, including the Paradox, Piceance, Rocky Mountain, Gulf Coast, Texas, Oklahoma.
And you've also published a paper on reservoir engineering before, is that correct?
Yes, but we published an SPE paper with a project that I did in Italy concerning the analysis of production trends versus performance of well bores.
Okay. With that summary, Mr. Chairman, and also with the other information on Mr. Mabey's resume, I'd ask that the board recognize him as an expert in petroleum engineering for purposes of this cause.
Mr. Alder.
I don't have an objection to his being recognized an expert. I would ask a clarification. Did you say you started with Fidelity in May of this last year?
May of 2015, yes.
And you said you had prior experience in the Paradox. Was that for another company?
Correct.
What company was that?
Worked for a company called El Paso. They're no longer, well, they're EP now, but we had production in the Paradox. And also Bill Barrett Corporation, which had production in the Paradox in Colorado.
Thank you, Mr. Chairman, for that liberty. No objection.
Board members, any objections? Then Mr. Mabey will be admitted as an expert for purposes of petroleum engineering.
Okay. Mr. Mabey, I'm now going to show you what have been marked as Exhibits G through O and Replacement Exhibit P for purposes of this cause. Were they prepared by you or Fidelity personnel with your input and review?
They were.
And again, at this point, I do want to remind that Exhibits K through O are deemed confidential and for in-camera review only. No PowerPoint will be provided, and the exhibits, once exhibit, are to be protected from public access. Turning your attention then to Exhibit G, please explain to the board what this represents.
Yep, so this is a production history for the Cane Creek Unit 7-1. It shows oil and water production on a semi-log axis on the left-hand side and gas and GOR on the right-hand scale. It also indicates that the total production from this well has been just over 34,000 barrels to date. And it also indicates 2 breaks in production. This is when the Clastic 1819 were added back in July of 2014 and then again in November of 2014.
Okay, and just so the board has a heads up, this is information that is utilized in your projection of the drainage area, is that correct?
It is. I utilize this information in the decline curve analysis.
Okay. Turning your attention now to Exhibit H, please explain to the board what this represents.
This is simply a schematic and details of the well construction, indicating the directional survey, where the casing and tubing were landed, and then also the perforated intervals. This is from a modeling software package by IHS called RTA.
Okay, then now directing your attention to Exhibit I, please explain to the board what this represents.
Exhibit I are simply phase diagrams for the petroleum to oil phase, representing standard industry correlations for pressure, volume, temperature correlations, specifically standing, and then viscosity correlations using Beggs and Robinson. And essentially, this is how the model treats the oil properties as the reservoir pressure declines with time. The takeaways on this slide, I think, are the oil formation volume factor, which is a number that represents the volume of oil in the reservoir compared to it on surface, and that number is 1.36 barrels per stock tank barrel. Also, too, you note that our bubble point pressure is indicated along with the oil gravity and reservoir temperature.
Okay, directing your attention now to Exhibit J. Please explain to the board what this is.
Yep, this is just a synopsis from the reservoir modeling program that I utilized. The description is of a horizontal multi-frac, uniform frac model, and it essentially outlines the methodology the model utilizes to calculate reservoir radius or recovery factors.
So this is just a summary of the model that was utilized that you're going to talk about next. Is that correct?
That's correct, yes.
All right. At this time, I would ask the board and the division to look to Exhibit K, which is one of the in-camera reviews. And Mr. Mabey, could you please kind of give the highlights of the points of Exhibit K?
Yep, so Exhibit K is results of the horizontal multi-frac reservoir simulator, call it an analytical model. Essentially what it does is it takes various parameters and makes those variables in the equation to solve the resulting pressure history of a well. So the assumptions made in this model are initial reservoir pressure, porosity, permeability, water saturations, which are all log derived. And then, my task was here to figure out how much area this well was actually capable of draining. And so to that end, the fracture half length, which would be equivalent to the reservoir width, was set as a variable, along with a number of naturally encountered fractures, which is basically an unknown parameter for this well. And turning this model into action, it's trying to match the outcome of the model with the actual historic production. And I attempted to match the production between January of 2014 and June of 2014, which is essentially the King Creek unit production. So my challenge was to vary the reservoir width with the known reservoir parameters to come up with an adequate fit of the actual historic data. One of my challenges is how many natural fractures did the well actually encounter. I'll show you on the next graph that I have a methodology for how I determined that this well encountered 5 natural fractures. But as a result of that encounter, the parameters utilized the reservoir model indicated that somewhere around 130 feet, 139 feet of fracture half width, or 280 some feet of reservoir width, provided a goodness of fit of about 14% error. And so I felt pretty comfortable with this result, especially when taking into account the type curve fits of the data, which are on the upper right-hand side and the lower right-hand side, the Blasingame type curve match, and then the log-log pressure history of the well. The next slide.
Okay, moving on then to Exhibit L. Please explain to the board what that represents.
So as I said, the challenge here was to estimate the number of naturally occurring fractures that the well encountered, and based on field typical permeabilities for the King Creek, which is indicated there, the number of natural fractures was found to be somewhere around 5 natural fractures encountered in that wellbore length in order to get an appropriate magnitude of permeability.
Directing your attention then to Exhibit M.
So M is simply a cartoon schematic of the resulting wellbore horizontal lateral, which indicates a reservoir width of 278 feet and a drainage area, a resulting drainage area of around 25 acres.
Turning your attention then to Exhibit N1.
Before you leave that, I'm not sure I understand what you just said.
Okay.
Would were you talking about the depth, I mean, the thickness of the paradox there? And well, I don't understand what you just testified. It's not challenging it, I just don't understand it.
That's fine. So
On that Exhibit M.
reservoir width would be perpendicular laterally to the horizontal, while thickness would be the H of the King Creek unit. Our thickness in that area is 78 feet, but the width, how far away from the well the drainage is occurring, was
Okay.
the 278 number.
It's you would say it in terms of the fracture length. You're saying the width of the formation, and that's what's throwing me here. So,
Yeah, so what I'm trying to convey is the drainage
correct
width of that well bore. The length of the fractures essentially would be the width of that reservoir, that drainage area, and that's 278 feet.
And this is
Okay.
derived from the model, is that
That's
correct?
correct, yeah. So I know it gets confusing because we throw in half length and width and all that, but essentially it's just a rectangular drainage pattern.
When you get to half-life, you let me know.
Hopefully none here.
Okay, now directing your attention to Exhibit N1.
Yep, so this is simply a conventional decline curve analysis. Again, this is the historical production from the well bore. And what I did was I applied a curve fit to the first production interval, which was from January 2014 to June 2014, and estimated from that fit an expected ultimate recovery for this production. Now, the reason why I chose to do that period is because that was unencumbered by any effects from the addition of the 1819. So this would simply be the King Creek. However, you can see that after we added the 1819, there was really no material effect to the production curve. In fact, you might say it actually went less than what it had been. So this is just, excuse me, a decline curve analysis on the actual oil production.
Turning to N2 then.
N2 is another representation of the same thing, except that instead of time on the x-axis, it uses cumulative oil production. And so the straight line relationship between oil rate, semi-log oil rate, and cumulative production projected into the future gives an indication of expected ultimate recovery of oil.
And what's the relationship then? Do you expect that you're going to recover all that estimated?
No, typically decline curve analysis will estimate high, primarily because as the reservoir pressure declines, you eventually hit the point where gas will come out of the oil bubble point. And once gas comes out of the oil, it changes the nature of the decline curve, and because gas has a preference to flow through the reservoir, it ends up leaving oil behind.
Turning your attention then to Exhibit O. Please explain the board what that
Yep, so
represents.
this is simply reservoir volumetrics, and in it I utilized the reservoir width, which was 2 times the fracture half length, so the 278 feet. the amount of perforated interval in that lateral. The expected drainage radius was calculated at 25 acres. The thickness of the King Creek from the log analysis, along with porosity and water saturation. And then the B sub O tells you how much oil is in the reservoir compared to how much oil would be at surface. So that's a 1.36 surface barrels for every reservoir barrel. And what I did was I adjusted the recovery factor, how much of that oil can you physically get out of that reservoir, until it matched what the expected ultimate recovery was from the reservoir model. And in order to do that, I had to increase that recovery factor to well over 26%, which, although technically feasible from the fact that the B sub O is rather high, it probably is higher than what it physically should be. And so utilizing those three techniques, the reservoir model, the decline curve analysis, and then the volumetrics, I can confidently say that the volumetrics indicate that expected recovery is probably going to be less than what the reservoir model indicates and the decline curve analysis indicates, and that as a result, the true reservoir drainage area is probably going to be less than what the model indicated, and results that the drainage radius is going to be less.
Okay. Turning then to replacement exhibit P. Please explain what this represents.
Well, this is the actual well bore as measured from directional surveys. You'll see that the well initially started to the north and then turned to the northwest once the King Creek was encountered. The solid black lines surrounding that well is the 130 feet, so 260 feet across. And then the yellow lines are the setback distance of 660 feet.
And this also shows the second well bore there. Can you kind of give the board a little bit of information about that well bore?
Yep. So the King Creek Unit 7-2 was drilled and never completed. It was drilled to the northeast, in a northeast direction, and that well also landed in the King Creek.
Yes, right on the corner.
So the landing point is actually, the landing point in the King Creek is actually indicated by that black dot there, which is right at the edge of that requested spacing unit.
Okay, so if I can kind of summarize a little bit on this, then is it your opinion then that the box is probably a greater amount than the 7-1 would ever really drain, and therefore we really don't, it's not a concern, there wouldn't be any lands drained outside of what's shown in the blue or the requested spacing area?
That's correct.
Okay. And also, based on your knowledge, if you maintain a 660-foot setback from the lateral, do you think there would be any communication with any other well?
I do not.
Thank you. So based on your expert opinion, then, the proposed drilling unit is not smaller than the maximum area that can be economically and efficiently drained by the 7-1 well?
It is not.
Chairman, that concludes my examination. Mr. Mabee.
Mr. Alder, Division.
Yes, thank you, Mr. Chairman. A few questions. You know the distance, Mr. Mabee, from on Exhibit P, replacement Exhibit P, from of that black boundary, the 139-foot distance from the wellbore, and the southeast corner of the southeast quarter of Section 6? Towards that quarter section, it appears to go very close to it. Do you know the distance?
I don't have that exact distance.
I assume you project, or your projections would be that it is entirely within the southeast of the southeast. It doesn't extend.
Oh, yeah, I see what you know, you're correct. Yeah, the drainage radius or the drainage width of that lateral does not actually extend past that spacing unit,
You don't know the distance?
but I don't know the distance. It's more than 130 feet.
Does the company know the distance?
We could calculate it, but
Wouldn't that be important to know?
well, except that it was within the space unit, and so then, that's all I was really concerned about graphically.
You talked about, there's been testimony about perfs and about fractures, and your calculation of this model showing the drainage area, is that primarily directed toward drainage out from areas that have been perfed, or does that refer more to drainage from the 5 fractures that you talked about?
Yeah, some of the shortcomings in these models, of course, is that it assumes a uniform homogeneous reservoir, which, none exist on this planet, and that the encountered natural fractures are uniform in length and spacing. So the drainage that was calculated is actually from the end of those fractures, the calculated fracture length, to the horizontal wellbore.
Your model showed 5 potential fractures?
5 potential fractures, that's correct.
But did it indicate in any way the location of those fractures along the wellbore?
Not at all.
And the conclusion was that the greatest extent from the wellbore of those would be 139 feet?
Yeah, and I caveated that by putting a plus or minus there because, of the inconsistencies in the model and variability of the reservoir and fluid properties within the.
What is the plus or minus error?
Well, the model calculated an error of 14%.
14%, okay. Like 20 feet? Okay.
Yeah.
Not great at math.
16 feet.
Is this model used by other companies in the industry?
It is. I've actually used this model in my previous role with Source Energy in Kansas, which was a naturally fractured limestone.
And in your experience, is this model appropriate for use in this kind of clastic environment?
It is, especially given the relatively low permeability of the reservoir. The lower the permeability, the less the drainage area, and so you have to provide some mechanism for that fluid to actually get to the reservoir, and that's where the fractures come in, or the fluid get to the wellbore, sorry.
And this isn't a model that you developed. I mean, this is a model you've used.
Yeah, no, I did not. I would not take credit for the model. It's an industry model.
And has it been reviewed by industry or publications or any scholarly?
Yep, the model was first presented, and I think I gave a reference to that in the description of that model. Yep.
Okay,
So
thank you. I may have not been paying.
No, that's fine.
All right, and so in your opinion, this model is appropriate and is reliable for this purpose of determining the drainage area?
I think it is, yes.
Thank you. That's all the questions I have, Mr. Chairman.
Thank you. Board members, any questions?
We've seen a lot of wellbore diagrams and decline curves that are public information. What is the confidential nature of these exhibits? I don't understand that at all.
Generally, these are interpreted results. The numbers utilized are not generally public information as far as the log drive parameters. I don't know that anything as super top secret, but they are interpreted and calculated numbers so that they are proprietary in how we do those.
Thank you.
Any other questions? Back to you, Mr. McDonald, for entry of the exhibits.
One follow-up, Mr. Chairman.
Oh, yes, please.
Mr. Rogers had one follow-up question he'd like
Yes.
to ask, if that's possible.
Talking to some individuals at Fidelity, they indicated that they were possibly going to do some mini fracs, whatever that means down there. Was this well one of those that had that?
No, this well has never been stimulated.
So there's not been any kind of microseismic fracking survey on it that you could.
Is that it?
Yes, thank you, Mr. Chairman.
Back to you, Mr. McDonald.
Okay, Mr. Chairman, just one redirect for Mr. Mabey. Mr. Mabey, though, given the fact of the modeling and then the additional analysis with the decline curve analysis and your volumetrics, so you're confident, though, based on this well, that it's not going to drain any area outside of the requested drilling unit areas. At this time, I would move for admission of exhibits A through O, replacement exhibit P, exhibit Q, and exhibit Z as supplemented, with the caveat again that exhibits K through O are confidential and proprietary, protected as such under the Governmental Records Access and Management Act, and therefore will not be available to the general public.
Division? Any objection?
No objection.
It has to do with the admission of the exhibits.
Yes, it does. Mr. Alder, could you give us your opinion on the confidentiality of these exhibits, why they would be confidential when other things we have seen are not?
We have discussed this. It's usually the operator's proprietary right or right to claim that certain exhibits are proprietary. As I understand it, it's based on the fact that this model has some, as applied, has proprietary interests. It is something that could be challenged by grandma if someone were to request this information. But for the purposes of this examination, the division's opinion was that the testimony of the witness was sufficient and that there was no reason to have the exhibits made public. We understand that that could be challenged, and that would be up to the board to decide then whether it was appropriate, but we thought that it would be appropriate for the hearing to go forward as it has.
So you're testifying that the model is confidential?
No, I'm not. I hope I'm not testifying as to anything.
Okay,
And
maybe that question goes back to the witness. Is this model confidential?
The actual model is not confidential. It's a purchasable software, industry software. But my parameters into that model are Fidelity-derived numbers.
It's the analysis and use of the model that's claimed as proprietary. It's not the model itself. Anybody could purchase that, but it's the analysis that went into the modeling that Fidelity is claiming is confidential. And as far as other operators, I think, as Mr. Alder pointed out, it's their prerogative whether or not they want to make the data public or not. Fidelity made that business decision that they do not.
Other questions of the board? So for clarification, we have exhibits A through D, and the clarification is that we have exhibit E-1 and E-2. Then exhibits F through J, exhibits K through O are confidential, and then we have replacement exhibit P, we have exhibits Q, Z, and the supplement to Z.
Correct.
And they are all admitted. How many members of the board have hard copies of the confidential exhibits? We would like to pick those up after the hearing and return those to you, Mr. McDonald, if that'd be okay. So I see the answer to that to be three sets. Okay.
Mr. Chairman, I think there will be a hard copy with the division, however.
Yes, there will be a hard copy with the division. I'm just talking about board members. We don't want to leave.
Well, there will be one for the record as to Ms. Davis's question
Yes.
if someone were to subsequently want to
Yes.
examine that and make
yes,
that argument.
That would be necessary.
Okay. thank
But
you.
it's not necessary for the board to have those laying around, and we just return them. Okay, we're now to the division. Any,
Mr. Chairman, this is a kind of an unusual matter. It's driven by the determination by the BLM. I don't know if it's appropriate to ask for their comment, but I know their original record is, their original letter is in the record. I think the division's position with regard to the request is that it's based on substantially evidence that's based on the expertise of these witnesses and Mr. Mabee particularly, and we certainly are not in a position to contradict that testimony and think that it reasonably supports the request, and therefore we do not object to it.
you will invite Bureau of Land Management. Do you have anything to say on this? Please identify yourself.
Mr. Chairman, members of the board, my name is Michael Coulthard, and I'm a petroleum engineer with the Bureau of Land Management at the Utah State Office. On October 14th, 2015, the Bureau of Land Management sent a letter to the board stating our support for the request for agency action. I know that this is somewhat unusual, so if there's any questions that the board would like answered, I'd be happy to answer them, and I'd also be happy to be sworn in if you feel that anything may be testimony as opposed to, statements of fact.
I think the letter is self-explanatory, and for the record, that's Exhibit Q.
Actually, I think Exhibit Q is our letter basically to Fidelity stating that the well is non-paying and giving them 4 options to take care of that.
The October 15th, 2015 letter from the BLM, and I think that's what Mr. Coulthard is, that was filed to the board as part of this cause.
So it's not one of the exhibits?
It's not one of the exhibits,
I'm
but it's
sorry,
on,
I got that
it's
wrong.
part of the record already.
Okay. Board members, any questions? Seeing none, thank you very much.
Thank you.
Okay, we're back to you, Mr. McDonald.
Thank you, Mr. Chairman. Again, I appreciate the indulgence of the board with this circumstance. This is unique as far as the way that this was presented, but I think bottom line, you understand that if the well is not a unit paying quantities well, there has to be a spacing order in place to properly allocate the production. The parties here will be protected that way. It leaves the opportunity that if the lands or the well ever do meet the unit requirements, then it would be brought into a PA and the unit agreement would govern at that point. So with all of those parameters, I believe my client has established its case for the establishment of the special drilling unit and that the correlative rights of all parties will be protected in this case. And we thank you again for your time and attention.
Thank you very much. And thank you to the witnesses. This was a tough case. Thank you to the BLM for and the division on this matter. Board members, would you like to adjourn and discuss this, or would a motion at this time be in order? Motion then? Okay. Mr. Moon?
I move that this request be granted.
Is there a second?
Second.
Is there any discussion of that motion? The motion before you is to approve and grant the request for agency action as written, with the clarification from the division that if the spaced area is included in the unit, you will notify, there will be a notification to the division for their records. And Mr. McDonald, okay, so that motion is before you. All in favor, say aye.
Aye.
Any opposed? Let the record show that that was unanimous. And Mr. McDonald, will you prepare the order?
Certainly, Mr. Chairman, thank you.
I don't believe there are any other matters to come before the board. We do have some discussions we'd like to have as a board. We'd like to at some point invite you, Mr. Bozza, to join us for just a short one. Mr. McDonald, exhibits.
Thank you, Mr. Chairman.
Exhibits are right here. And with that, a motion to adjourn's in order.
So moved.
All in favor, say aye.
Aye.
We are adjourned.